The High Court in the Western Cape is discussing the envisaged impeachment process for Public Protector Advocate Busisiwe Mkhwebane. Our SABC News reporter Bulelani Phillip has been following this story and joins us now via Zoom. A very good day to you, Bulelani. What happened in court this morning?
Good morning to you, Desiree, and to the viewers at home. Well, it's quite a tense, and I would say that it's quite a tricky legal process that's happening today, because you'll remember that last week the public protector actually had a legal blow to a case that was supposed to be heard today, and that case really relied largely on the effect of an earlier court of the Constitutional Court. Earlier on, the Constitutional Court ruled that she had a legal right of representation to the impeachment process of Parliament. Now, she went to court again to rescind that Constitutional Court outcome. Now, today what happened is that she's asking that the court must consider new facts which have not been tabled before the three justices that are being hearing that are hearing the case, which is headed by Justice Nathan Erasmus. Her application of rescission of the earlier court ruling last week simply means that Parliament has got a way of going ahead with that Constitutional Court outcome, which means that she has been given deadlines of how she must be able to conduct herself. And now part and parcel of the process is that she has to give the Section 194 Committee of Parliament that is investigating her fitness to hold office by the 22nd of June, which is next month. Now, the court now is seized with her application that was brought last month. This court application means that now, if she wins here, she can stall the processes of her removal from office. However, at the moment, there is nothing that is stopping Parliament from proceeding with this application or with this removal process of Section 194. So, in short, Desiree, the
Bulelani, are you still there?
I think I keep not hearing you. But in terms of the process as it stands now, the legal representation, which is Advocate Dalimpofu, is making representation to say that there are new facts and the High Court has to hear this case. But, however, the High Court has already ruled on this matter that the removal process must continue up until the point when the advocate Mkhwebane went to Constitutional Court to come and try to stop the process.
So Parliament has said previously that whatever new details the public protector has do not affect the merits of the case that's currently underway. Do we know what these new facts that Advocate Mpofu is talking about, and will they impact on the merits?
That's right. That's the point. I think Advocate Dalimpofu tried to impress on the three panel judges that were sitting on this case to say that there are new facts. However, he didn't elaborate on the terms of these new facts. And it's very tricky in the sense that the High Court has already ruled that this process should go ahead. And the public protector took this matter up to the Supreme Court and to the Constitutional Court. Constitutional Court said, fine, this process should go ahead, the rules of the National Assembly, which is what she was challenging. The rules of the National Assembly must be amended to such an extent that she has to have legal representation. Parliament has acceded to that particular request. And then when the committee decided in the middle or late February that the process has to go ahead, the public protector then applied again to the Constitutional Court to rescind the earlier judgment of the Concord. In that rescission application, which was dismissed last week, again, it begs the question, how even this case has to even to be heard? Because every application that she has brought was pending the outcome of the Constitutional Court ruling, which was delivered last week.
I like how you add in Ukuba. You want to make that point. Bulelani Phillip, thank you so much. Thank you so much for talking to us. And of course, it's a case we continue to follow.